attorney? Do you understand those rights? You do have the right to be represented by an attorney, and if you could not afford one, one would be appointed to represent you at public expense, but you may have to repay a portion of that expense. Do you understand that? Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I have an attorney that I've already spoken to.
Okay, who was that?
Greg Demopoulos.
All right. I'm going to mark that you're hiring an attorney.
But I also.
Yeah, so they're required to meet with you, but you always have the option to hire your own. Now, if something happens that the attorney that you're working with doesn't work out, you want to let that person go, you can always hire a different attorney or request the appointment of an attorney. All right. So the court will enter a not guilty plea on your behalf and will set the matter for a pretrial. That's a hearing that's here in the district court where your attorney and the prosecutor will see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I show that a $500 bond was posted over the weekend. Any comment regarding bond?
Yes, Your Honor. In order with the property. Your Honor, I would ask that if there's a no contact order with the location that this incident took place, that he lifted, he runs a business out of the location. Or I would ask that it be modified insofar as that she can retrieve her business goods and things along that nature, if possible. Other than that, I have no problem with the no contact order with the alleged victim. Thank you.
All right, Mr. Khan.
Your Honor, I would ask for a no contact order with Kyle Hubble, other than anything else in the court's discretion.
All right. I'm going to continue the bond as previously set. You are to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no crimes. I'm also going to order that you not have any contact with Kyle Hubble. No contact means no contact of any kind, not by phone, text, email, social media, anybody acting on your behalf. If you are found to be in violation of the terms of your bond, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that? Okay, you can go out to the front window where you checked in, get your next court date, make sure your attorney gets that court date, because until they file an appearance, they're not going to receive any communication from the court. Okay? All right, thank you. Person at the jail, what is your name?
Jason Andrew Troubles.
This is case number 253911 FY, the people of the state of Michigan versus Jason Andrew Couples. Mr. Couples, is Peninsula Drive a good mailing address for you?
Yeah.
And do you have a phone number?
It's on my phone, but I can't remember it.
All right. Did you have the opportunity to meet with somebody from the defender's office?
Yes, sir.
I have a complaint that alleges that on or about September 1st, 2025 in Herring Township of Wexford County, it is alleged in count number 1 that you committed the offense of possession of methamphetamine. That is a felony punishable by up to 10 years and or a fine of $15,000. The prosecution has also elected to charge you as a second subsequent offender, which means that you have at least one prior drug conviction in your past. That makes that 10-year felony a 20-year felony, and the 15-year felony a 30-year felony. Additionally, they've also elected to charge you as a habitual fourth offender notice, which means you have at least 3 either completed or attempted felonies in your past. Now, they can't move forward on both the fourth offender or the second subsequent. They would have to choose one to move forward on. But that fourth habitual makes the 10-year felony a life offense. Do you understand that?
Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and you have the right to stop answering questions at any time. You also have the right to be represented by an attorney, and if you could not afford one, one would be appointed to represent you at public expense, but you may have to repay a portion of that expense. Do you understand that?
Yes, sir.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request for attorney.
I'm sorry,
Request for attorney.
what is your current source of income?
Nothing.
Court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea and we'll set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution is required to prove two things. One, probable cause that the crime had occurred, and two, probable cause that you were the person who committed the offense. If the prosecution is not able to do that, the case will be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I show in 19 a possession of contraband in jail, 21 possession of meth, 22 possession of meth. In 18, there was a 7411 case. Then out of state in 94, there was a theft of a coin machine, 94 trespass, 2 counts of that. 95, a burglary, assault and battery in a public place. 98, assault times 2, so two assaults. 98, it looks like 2 damage to property convictions and an assault. 98, a shoplifting, 02, a burglary, and 08, damage to property in public. The praxis scores him at a risk level 4, so medium risk. Any comment regarding bond conditions? Defense?
Yes, Your Honor, I will state this case likely to be conflicted out, so I was kind of delicate with the questions that I asked. But I will note that he has some health problems that are exacerbated by being in jail, necessary. Mainly his diabetes and then some seizures that he gets or often gets related to that. Or I don't know if that's related to that. I'm assuming that. He lives in Traverse City, which is not too far away. And I would ask that a low cash bond be set. Thank you.
Thank you. I should have noted bond was previously set at $50,000 over the weekend. Any comment regarding bond, Ms. Carey?
Thank you. People are going to ask that the court frankly raise the bond. This was the result of a traffic stop. Although I'm not 100% Mr. Couples was a passenger, there was a backpack with some of his belongings in that, and included in that were 5 grams of suspected methamphetamine, a digital scale, and a plastic bag. There is a co-defendant who was also in the vehicle, who I believe is the driver, and in the I want to say in the trunk. In the trunk, there was a duffel bag, and it had 220 grams of methamphetamine and 26 grams of fentanyl. So I think that Mr. Couples, given his record and the quantity of meth and fentanyl found, although he was only charged with so far what was in the backpack. But given the circumstances, I believe a high bond is appropriate. Thank you.
Thank you. Given what's been presented today, even though this is charged as a controlled substance possession of methamphetamine, I do believe that the defendant does pose a threat to the community based on the sheer weight that was found within the vehicle. And in his personal belongings. Bond will be set at $75,000 cash or surety with the following conditions: that the defendant not consume any drugs, no recreational marijuana, he be subject to random testing. I do find also that given the potential the potential sentence in this case, in that the defendant has at least 2 prior high severity felonies in his past and is now charged with yet another high severity. He is potentially looking at some prison time, at least by my scoring in my head. So I do find him a flight risk as well, and he'll be subject to a GPS tether for location purposes. Anything else in a pretrial release order, Ms. Carey? Ms. O'Mara?
No, Your
All right, thank you. Next arraignment.
All right, let's talk about that. This arraignment in front of Judge Corey J. Wiggins had all the ingredients of a high-stakes case: multiple felony allegations, a defendant with a long record, a bond argument that touched on health concerns, and a prosecutor pointing squarely to the sheer weight of drugs found in the vehicle. Judge Wiggins's demeanor was steady and deliberate. He wasn't rushing through the charges, and he made sure the defendant fully understood just how serious the habitual offender enhancements made things during Dant. Jason Andrew Couples came across as polite but subdued. He answered clearly when asked about his address and income, admitted he had none, and requested court-appointed counsel. His body language and tone suggested resignation more than anything else. This wasn't his first time in front of a judge, and his criminal history backed that up. Wiggins recited the rap sheet: contraband in jail, multiple meth possessions, burglary, assault, property damage, shoplifting. The list seemed to go on. By the time the judge was done, it was clear Couples was carrying decades of baggage into this arraignment. Defense a cautious approach, noting up front that the case would likely be conflicted out of their office. Still, they made the key point. Couples suffers from diabetes and seizures, and jail was making his health worse. The ask was for a low cash bond, framed around his medical needs and his proximity to Traverse City. It was a respectful but uphill request, especially in light of the new charges. Prosecutor Ms. Carr, the sharper edge of the argument. She laid out the facts from the traffic stop: a backpack with Couples' belongings containing 5 grams of suspected meth, a digital scale, and a plastic bag. That alone was enough for the possession charge. But then she raised the stakes: the co-defendant's duffel bag in the trunk with 220 grams of meth and 26 grams of fentanyl. Her argument was clear. Given the context in Couples' record, this wasn't a case for leniency. A high bond was necessary to protect the community and ensure his appearance. Judge Wiggins weighed it all and firmly. He acknowledged the health issues, but ultimately focused on the public safety risk and the sheer weight of narcotics tied to the stop. Even though Couples was only formally charged with possession of the smaller amount, the surrounding facts painted a bigger picture. Bond was set at $75,000 cash or surety, higher than the weekend bond, and Wiggins added conditions: no drugs, no recreational marijuana, random testing, and a GPS tether if released. He even noted on the record that Couples was looking at real prison time if convicted, given the habitual fourth enhancement, which could stretch a 10-year felony into a potential life sentence. The courtroom atmosphere was calm, but undeniable. The defense's soft appeal to medical needs clashed with the prosecutor's hard numbers on drugs and prior convictions, and Wiggins handled both without raising his voice or showing impatience. He was firm, fair, and clear, making sure the defendant understood both the charges and the stakes. Couples himself stayed quiet and respectful, but the weight of the charges and his past hung over the whole proceeding.